The literal moment the conference call was over, they filed this notice saying she refuses to dismiss with prejudice. And so she's, screwing around with us. And at the very same moment, all of the tabloid publications had the story, which makes it clear that what they did was try to set her up again using the public docket by making her seem crazy.
Not cool, man.
Welcome to Law and Chaos, where Justin Baldoni's lawyers are wilding out, the Justice Department is suing to purge North Carolina's voter rolls, and pillow pumper Mike Lindell is teaching us about journalism shield laws. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you?
I am all right, except that we are recording this a day early because one of us is going on vacation. And I feel like probably one or two things might happen.
That it's a safe bet that the minute we stop recording, something is going to happen. So, might as well celebrate my brother's birthday. So,
all right. Well, happy birthday, Sean. Okay, let's do some docket alerts. First up, the case of Kingdom v. Trump. That is a challenge to the Trump administration's effort to restrict gender-affirming health care to transgender prisoners. The judge is Judge Royce Lamberth in D.C. He is one of what we call the old bulls. He was also the judge in Doe v. McHenry, in which he granted a preliminary injunction against transferring trans inmates to prisons that do not conform to their gender identity. He ruled that it violated laws which require the Bureau of Prisons to ensure that prisoners don't get raped.
Yeah.
And there is much higher incidence of sexual assault and rape on trans prisoners in prisons where they do, particularly for trans women who are transferred to men's prisons.
Yeah, that's right. And again, Royce Lamberth was for decades the most conservative member on the U.S. District Court for the District of Columbia. And I think it's just illustrative that, we have an administration that is no longer even pretending to practice law, governance, politics, right? Like it's all just outrage politics and who cares who gets hurt. And I got to say, I am impressed that Judge Lamberth cares about this segment of society that's getting hurt.
Yeah, his opinions have been really moving. I find it personally moving, as you said. Look, Judge Lamberth is 81 years old, and I'm not saying that there's an excuse when he might not understand concepts of gender identity, but I have a lot of respect for these people who grew up in a different time and have the integrity to continue to grow.
Here.
Obviously, the president put out a really bigoted and gross executive order. And he treats people who are transgender as sort of like as ideologies and not as human beings. And so Judge Lamberth says, by taking hormone medications and accessing social accommodations, the plaintiffs do not seem interested in propagating any particular ideology. To the contrary, their sworn declarations make clear that they are taking these measures to lessen the personal anguish caused by their gender dysphoria, a benefit on which they have relied for years under the Bureau of Prisons' longstanding policy of providing this type of care. In light of the plaintiffs' largely personal motives for undergoing gender-affirming care, neither the Bureau of Prisons nor the executive order provides any serious explanation as to why the treatment modalities covered by the executive order or implementing memoranda should be handled differently than any other mental health intervention. Nor does the executive order make any effort whatsoever to explain how providing hormone medications or social accommodations to prisoners hampers, quote, scientific inquiry, public safety, morale, trust in government, or any other virtue animating the executive order.
Yeah, that's right. I mean, eventually this is headed to a Supreme Court that allowed Donald Trump to kick all trans service members out of the military. Yeah. So, I don't have a lot of confidence, but I am happy to see this result for now, and we shall see.
Right. So Judge Lamberth certified these prisoners, all trans prisoners, as a class, and said during the pendency of this litigation, the Bureau of Prisons is required to restore and maintain access to those treatment modalities for those who previously received them pursuant to a prescription rendered by BOP staff. And moreover, if BOP medical personnel subsequently determined that an existing or future class member, that is, a new prisoner, is in need of either or both of these treatment modalities, the BOP may not take those treatment options off the table while this dispute is pending. And he said under the Administrative Procedures Act, BOP may not arbitrarily deprive inmates of medications or other lifestyle accommodations that its own medical staff have deemed to be medically appropriate without considering the implications of that decision. And he said, look, it was not a very long opinion, but he said, look, I appreciate the argument here that the executive branch is chosen by the people, the president is chosen by the people, and that he or she should be entitled to kind of effectuate their own policies. And yet the Administrative Procedures Act restrains a president from sort of doing any old thing that he wants to do. Remember this.
Right, minimally.
Minimally, right. And Judge Lamberth is the same one who enjoined the shutdown of Radio Free Europe, Radio Liberty, and Voice of America. So he has taken a strong sort of stance against this administration. He says, even if the Bureau of Prisons did support such a decision with consideration, study, and reasoning that the AP requires of it, that is, its decision to revoke medications and treatments for gender-affirming care, its freedom of action may nevertheless be constrained by the Eighth Amendment of the Constitution, but that is a matter better left for another day, whether that be a later stage of litigation or another case entirely.
Yeah, and that is a reference to the Eighth Amendment's prohibition on cruel and unusual punishment. And so what Judge Lamberth is saying is, look, I don't have to go out on that branch and say that housing female inmates with male inmates in prison is cruel and unusual punishment for the heightened risk of rape, for everything that you've talked about. I don't have to make that determination right now. But I'm flagging that option remains out there, even if this administration comes back and dummies up a bunch of studies and meets the threshold for, the bare minimum threshold for the Administrative Procedures Act, showing that the agency's actions are not arbitrary and capricious, right? Like that's the lowest possible bar that they have to clear. And Judge Lamberth is saying, even if you manage to get over that, which you haven't yet, there may still be other obstacles.
Okay, well, now moving from the sublime to the ridiculous. Ed Martin, the never will be U.S. attorney for the District of Washington, he's back in the news because he's in charge of pardons at the White House now because we live in hell. And he announced that he is going to investigate President Biden's pardons from the end because something auto pen and maybe Joe Biden was non compos mentis and somebody else convinced him to sign the pardons. This is, it's ridiculous.
It is fractally ridiculous, right? The job of the pardon attorney is to make recommendations to the president as to who should receive pardons, not to review pardons that were granted by prior presidents. I guess there's not a lot of that job to do because it's just, for sale to the highest bidder. Let's be clear. The president does not have a lot of plenary authority. We've talked about this on the show, but one of the powers they have that is plenary is the power of pardon. No court can look at it, can evaluate. This is just an administration that lives by Twitter memes, right? And
I think you're being a little too deep about it. He's just wanking. It's just wanking. It's executive branch wankery, and he really just should go to the men's room and not subject the rest of us to it.
All right, next story, Liz.
Okay, well, the next story is no less ridiculous, and it is that the White House or the Justice Department, not that there's really any difference between the two anymore, but the Justice Department has dropped a civil suit against Peter Navarro. This was an action in replevin, which is something that we all learned about on the bar exam and then immediately forgot until Peter Navarro reminded us. When Navarro left the White House in 2021, he failed to turn over emails stored on his Proton Mail account, most of them, I think, having to do with COVID. But he failed to return these emails as required by the Presidential Records Act. And the government sued him and said, hand that stuff back over. And he said no. And Judge Colleen Collar-Catelli in the U.S. District Court in the District of Columbia said yes. And then what ensued was like 2 years of wrangling, as Navarro said, I really did it. And the government said, no, you didn't. But now Trump is in charge and they've just dropped the case because they don't give a shit.
Yeah, replevin is an action to restore property that has been wrongfully taken by another. I could rabbit trail on this for a very, very long time, but I won't.
I think we have on this show.
Probably. And emails that concern the functioning of the executive branch are, as you said, under the Presidential Records Act, the property of the American people. They belong to us. They do not belong to Peter Navarro. And so there was a years-long effort to try and get those back. And now the government says, he's our buddy, so we don't care.
Yeah, and I mean, not that you needed further proof that they were full of crap when they said that Hillary's email was the biggest scandal that ever was.
Oh,
but
man, dude, I almost remember that.
Yeah.
Oh.
And on a more serious note, Judge James Boasberg in the federal court in D.C. has issued a ruling in the J.G.G. case, which started the whole Alien Enemies Act dispute. You'll remember that he tried to stop the planes that were taking off from CCOT and then had the legs kind of kicked out from under him by the Supreme Court that said, well, you can't file an Administrative Procedures Act. You have to file all of these, deportees had to file habeas claims. And, we're several months on from that now, and we're arguing about what kind of notice they have to get, and can they be deported with pending habeas claims, etc. But meanwhile, Judge Boasberg still has jurisdiction over that case, and the plaintiffs moved to amend their complaint in two ways. First, they wanted Judge Boasberg to issue relief to the men who are already deported to CCOT and did not get to raise habeas claims in this country. And second, they wanted him to certify as a class all of the potential Alien Enemies Act deportees in the United States across all of the districts. So they had two asks. And so Judge James Boasberg, with respect to the CCOT plaintiffs, there was kind of a threshold issue of whether they are in the constructive custody of the United States now, right? We know that they are held in CCOT in that Gulag prison in El Salvador, but the argument that the plaintiffs here made was that really they're constructively still in U.S. custody because the United States is paying to hold them. And Judge Boasberg said, look, I've looked at a lot of sealed documents. There's been a lot of redacted stuff in this case, sealed filings. And he said, he didn't exactly say the government is full of shit and they are lying, but he strongly implied that the government, he certainly strongly implied, particularly that Michael Kozak was one of the declarants in this case, he basically said, I know you're lying, but I can't say that I know you're lying. And since I can't find proof that you're lying, I'm going to have to treat what you said as true. And taking what the government said as true, he said, okay, it would not appear that from a legal perspective, these prisoners are within the constructive custody of the United States. And so he said they don't get habeas relief. The CCOT plaintiffs don't get habeas relief.
But he did grant two forms of relief to that class, right? The first that I don't want to pass too lightly over is certifying the CCOT plaintiffs as a class, right? That was initially a determination that he had made provisionally for the purposes of a temporary restraining order. And now this opinion says, yes, this qualifies for class action relief, and it runs to all of the individuals who are involved, who are being detained in CCOT. And second, he entered a preliminary injunction saying, okay, if I'm not going to grant habeas relief, here is the law. And it is 12 pages of dense legal analysis that you and I went back and forth over that says, look, even when you are bringing the underlying claims as a habeas action, the preliminary to that, the procedures that you are challenging under due process fall outside of habeas, right? And the law on that is very, very clear, right? There are myriad cases in which prisoners who have brought habeas petitions have also brought other legal challenges, and where the habeas petition itself would not result in their release from confinement, right, like where they've asked for alternative medical care or the like, then courts have said that means that habeas is not your exclusive remedy, and we're going to examine the merits of your due process claim, particularly when it comes to notice. And that's what he says here. So then a couple of things. Number one, this opinion is really, really moving, right? Like it begins with 2 pages of quotation from Franz Kafka's The Trial. And like, Kafka, there's a reason Kafkaesque is an adjective, right? Like that is absurdist literature. And this is Judge Boasberg saying, look, I want everyone to keep sight of the fact that what the government did here was backfill a bunch of pretextual reasons. And I know the Supreme Court blessed it and ultimately said file in habeas, but they tried to shuttle these folks around and get them out of the country without their having meaningful notice that they were being shipped to an overseas concentration camp. And that's the worst of us. And it is terrible. And so that kind of leads to the second point. As a result of those practical consequences, right, having put meat on the bones of what due process means, Judge Boasberg says that the class of CCOT plaintiffs, right, people who have been renditioned to El Salvador, that, quote, the government must facilitate the class's ability to seek habeas relief to contest their removal under the Alien Enemies Act. Exactly what such facilitation must entail will be determined in future proceedings. Although the court is mindful that such a remedy may implicate sensitive diplomatic or national security concerns within the exclusive provenance of the executive branch, it also has a constitutional duty to provide a remedy that will make good the wrong done.
Yeah. And look, we have seen courts kind of grappling with how to make the government follow the law. We're watching in the DVD case, which is in Massachusetts, those prisoners who were renditioned and stopped on their way to South Sudan. They're in Djibouti, and they're in theory getting some sort of procedure there to make claims under the Convention Against Torture, although there's
credible fear hearings. Yeah,
credible fear hearings. But there's actually, their lawyers have said that they have not been able to speak to these people, even though the government says that they are being given these credible fear hearings and access to counsel. So I think we're going to hear more about that. But these two things are of a piece, right? Judge Boasberg is saying, you're the ones that put them there overseas, so, figure it out how you're going to give them procedure. But like Judge Murphy in Boston, Judge Boasberg said, look, Trump administration, DHS, you're the ones that staffed these guys overseas, so I don't know how you're going to give them procedure, but you're going to give them procedure.
Yeah.
And just to end on a sort of funny note, you know how the Trump administration put out this ridiculous executive order that said that the government needed to ask for bond in all these cases, basically kind of like putting a ransom on anybody vindicating their constitutional rights.
Right.
And so courts have been handling this in a bunch of different ways. When Maine sued the Department of Agriculture to get its school lunch money back after Secretary Brooke Rollins punished them for letting a trans girl play sports, the judge in that case imposed a $1,000 bond. It was basically a de minimis bond. And here the bond, $1. $1 is a big middle finger to the government. Like, how dare you come in here? You deported these people to a concentration camp, to a gulag in El Salvador, and you want them to pay you? Are you kidding?
It's the bet from Trading Places, which I hope Judge Boasberg was thinking about Randolph and Mortimer Duke when he did that.
I kind of feel like he wasn't. I kind of feel like he was so mad. He wasn't thinking about anything funny, but it was funny to us.
Fair.
Okay. So today in the main show, we're going to check back in with Blake Lively and her lawsuit against Justin Baldoni, as well as the lawsuit by a Dominion employee against pillow puffer Mike Lindell. He's always good for a laugh. And then for our main story, we're going to talk about the administration's latest lawsuit against North Carolina to try to force the state to purge its voter rolls. But first, we have a subscriber bonus. We're going to talk about the latest one weird tariff trick that some people think the Trump administration will try now that courts have declared he can't just shout emergency and steal Congress's power over the tariffs. For everyone else, we will see you on the other side of this brief ad break.
And we're back. So let's start with the very real lawsuit filed by Blake Lively against her former director / co-star Justin Baldoni, and the much less real lawsuit that he filed against her. We talked about these in depth on episode 95. Basically, Lively alleges that she was sexually harassed on the set of a movie called It Ends With Us, and that Baldoni and producer Jamie Heath created a hostile work environment on the set of the film.
Right. She says that things were so bad on the set that she had to negotiate a contract writer with the production studio Wayfarer before she would agree to finish the film. The studio agreed in that contract writer to bring in an intimacy coordinator so there wouldn't be any more extras just wandering in who happened to be friends with Baldoni during her nude scenes, that they would take reasonable protections for her, such as when she was filming nude scenes, not having those nude scenes simultaneously broadcast to the iPad of every production assistant.
Gross. I hate it. So,
yeah.
After the movie wrapped, Lively alleges that Baldoni and Wayfarer were, worried about what she might say about what happened on the set of the movie, and they concocted a strategy to preemptively trash her in the Hollywood press, just in case she ever, went public with any of those stories. And again, this is a claim in a lawsuit, but that claim seems pretty plausible to me, given that while the movie was in post-production, all of these tabloids started publishing stories about how difficult it is to work with Blake Lively.
Right. So things came to a head in December of 2024 after Lively filed a sealed employment grievance in state court in California, and they shared some of the text messages that were produced during that proceeding to the New York Times, which published her story in an article titled "We Can Bury Anyone Inside a Hollywood Smear Machine."
Yeah, so as you might imagine, Lively sued Baldoni, Heath, and Wayfarer, as well as some of the PR flacks who allegedly orchestrated that smear campaign. Baldoni and Wayfarer sued the New York Times, and then later they sued Lively and her husband, Ryan Reynolds, because he's Deadpool?
I think they sued him because he has a shit ton of assets.
Right, because he's Deadpool.
It's not that mysterious.
Yeah, fair. Anyway, all of the cases wound up consolidated in the U.S. District Court for the Southern District of New York in front of Judge Louis Lyman, who has featured on this show on multiple occasions. And I said this the last time we covered this story. I will say it again. These are my opinions and observations as a practitioner. I think the core of Blake Lively's claims against Justin Baldoni are strong. I think Baldoni and crew's defamation claims against the New York Times are weak. They're basically like, you omitted the context of it, right?
And whatever. Look, they're ridiculous. The claims against the New York Times are the most ridiculous, right? Because the New York Times has the reporting privilege. They reported on a proceeding, right? They reported on the grievance she filed in the state of California. They're protected so many ways.
That's right, but I don't know. They're being given a run for their money by these guys' counterclaims against Blake Lively and Ryan Reynolds for I don't know. Yeah, I mean they're preposterous. They're Trumpian. They're in some cases, and there are pending Rule 11 sanctions motions, sanctionably bad. So again, it appears to me that Baldoni's legal strategy looks an awful lot like his alleged PR strategy, right? I mean, it certainly seems that his legal team is out to file stuff, the primary effect of which is to trash Blake Lively in the press rather than, to win arguments in front of a judge. I mean, that, effectively, as her lawyers have claimed, using the court docket to launder salacious claims about her.
Well, I mean, you don't have to worry about getting out in front of your skis there, since Judge Lyman already threatened sanctions against Baldoni's lawyers for doing just that. We talked about this a bit in episode 135, where Judge Lyman struck 2 letters filed by Baldoni's lawyer, Brian Friedman, from the docket. I'm going to read just a little bit of what Judge Lyman said when he did that. This letter is improper and must be stricken. The sole purpose is to promote public scandal by advancing inflammatory accusations, quote, on information and belief against Lively and her counsel. Retaining the letter on the docket would allow the court's docket to serve as a reservoir of libelous statements for press consumption. Counsel is advised that future misuse of the court's docket may be met with sanctions. That's the dorsal fin in the water, right? The Donna, right? Don't do that anymore that's not subtext. That's text.
Well, I heard the Jaws music, and let me say, kind of looks like Baldoni's lawyers tried the same stunt earlier this week, and I have to admit I fell for it.
Impossible.
So here's what happened. Remember at the outset, I said that my impression of the core of Lively's claims is that they're strong, right? Because they appear to be. Mm-hmm. But when you file a lawsuit, it is accepted practice. Everyone knows this. As the plaintiff, you allege everything you can think of, from the good arguments to the medium strength arguments to the less good ones, right? And this complaint has 13 counts. And at the time, I said I didn't think count 10, which was intentional infliction of emotional distress, was particularly strong. And that's because the standard for IIED is extreme and outrageous conduct that exceeds all bounds of that usually tolerated in a civilized community.
Okay. I mean, not to diss on Hollywood, but is Hollywood a civilized community?
Yeah, I can't. No, you've already been hitting California hard. Yeah.
No, I know, because somebody said to us and sent us a note that said we were slagging Brian Friedman for using California lawyer techniques in New York, where that shit wasn't going to fly. And somebody said to us, rightly, like, no. That's lawyers from LA. The rest of the state, we don't litigate like assholes. And so I will take that admonition.
You're still slandering a bunch of LA lawyers there.
I mean, you guys
but fewer. You're better.
Okay. But look, if you are claiming damages from emotional distress, the other side is typically entitled to discovery about your mental and emotional state. You have put that as an issue in the case, and they are going to ask for your medical records.
Right. And again, this is extremely normal in any kind of lawsuit, right? It's an application of the general principle that, you have an accident, you have to give the other side your medical records so that they know what your health was like before the accident, so they can figure out the delta. That's the damages that you're owed.
Mm-hmm. But if you're Blake Lively and your entire complaint is that these goons are trashing you in the media, you can definitely understand why she's not dying to give her entire confidential medical history to Justin Baldoni and all of these PR people whom she says are racing to, the Daily Mail and publications like that on the regular, particularly because, I mean, in this case here, tabloid reporters seem to have access to the Baldoni team's filings before they hit the public docket.
Yeah, agree 100%. But the implication of that is that you have to make a choice, right? You do not have to sue for emotional distress. And so that legal choice was the basis for this latest round of maneuvering, which, again, I just want to clarify that I fell for. So let me unpack exactly what happened. Baldoni's lawyers predictably asked for Lively's medical records, including any mental health care records. And Lively's lawyers said, no, we're not going to give you those. We're going to withdraw our intentional and negligent infliction of emotional distress claims instead. And again, that's how this works, right? Because if you're no longer suing for emotional distress, the court doesn't have to figure out the delta. Your emotional state beforehand is not relevant to the litigation. You can refuse to produce it. Baldoni's lawyers went to court because what they characterized this as, they said, look, we said, fine, but we want you, Blake Lively, to dismiss those claims with prejudice, meaning that she would not be able to file them again later. And then they claim that Lively's lawyers were only willing to dismiss without prejudice. So they said, there's no agreement. And they went in front of Judge Lyman with this letter motion to compel production of the medical records.
Right. So basically what they're saying is Lively wouldn't agree to dismiss the intentional infliction of emotional distress claim with prejudice. And so they will not be dismissing it because there's no meeting of the minds. And thus they need her medical records, and Judge Lyman ought to make her hand them over. And maybe we ought to play this out because the motion says that the harm that they're suffering, I mean, I know what's about to happen and I know that they're full of shit, but the harm that they claim is that Lively wanted to maintain the right to refile this emotional distress claim at an unknown time in this or some other court after the discovery window is closed, right? Because if the claim is dismissed without prejudice, then you're free to refile it. So what they're saying is like, well, maybe she's going to come back. And so if she maintains that right, we're not going to let her do it. And, she has to hand over all her doctor's notes and stuff.
Right. And that's the first sign that I should have picked up on, that maybe there was some gamesmanship going on. Because the first half of that is correct, right? That's what without prejudice means. But the idea that Blake Lively would refile those intentional and negligent infliction of emotional distress claims after discovery is just silly, because you can't do that, right? If she were to amend her complaint in this court after discovery had closed, or even very near the end of the close, and by that I mean within 6 weeks of the close of discovery, that would absolutely 100 judges out of 100 would grant the defendants a motion to extend time for discovery to, take discovery on this new claim. And remember, this is not a smart strategy anyway, because Blake Lively is the plaintiff on those claims. If she hasn't alleged them, she can't take offensive discovery, and she bears the burden of proof, and she would have no proof because she'd gotten no discovery. If she'd filed those claims in a different court, that would have its own discovery schedule, right? You can't file claims after the discovery deadline. That is not a real argument.
Right. Basically what you're saying is they're pretending that she's reserving the right to refile it, and there's a realistic possibility that she would, but there's no realistic possibility that she would. And she's got very competent lawyers. They're not confused either,
right?
Which explains Lively's response, which she filed the next day. And she called that a false and plainly improper public relations stunt. And she requested again that Judge Lyman strike one of their pleadings from the record, in which she called it a false and plainly improper public relations stunt, and requested that Judge Lyman strike it from the record. So what happened here, according to the Lively filings, is that after submitting the proposed stipulation saying that they were going to dismiss it without prejudice, Lively's lawyer said, hey, we have a conference call already scheduled for Monday. So let's talk about this on Monday, and, we'll have our back and forth, our colloquy, which the court expects us to do.
Right.
And then during that call, Baldoni's lawyers kind of didn't talk about the stipulation at all. And instead, the literal moment the conference call was over, they filed this notice saying she refuses to dismiss with prejudice. And so she's, screwing around with us. And at the very same moment, all of the tabloid publications had the story, which makes it clear that what they did was try to set her up again using the public docket by making her seem crazy.
Not cool, man.
No. And then there's a footnote that cites to an article in the Daily Mail tabloid titled "Blake Lively Makes Shock Move and Drops Intentional Infliction of Emotional Distress Claim Against Justin Baldoni," filed that same day, Monday, June 2nd. And by the way, out of curiosity, I wanted to kind of, after you and I talked about this, I checked Reddit to see how this was landing. And of course, it is almost universally landing she fucked around and found out, right? She filed this and then she was surprised that she had to hand over her medical records. He is indeed having success massaging the narrative in the public discourse.
Yeah, and I want to underscore the point you made earlier, right? Which was that Daily Mail story got published about 10 minutes after the pleading hit the public docket, right? That strongly suggests that the lawyers had leaked a copy of it to the Daily Mail and said, hold on, don't publish your story until we give you the green light.
Right. And look, I'm a journalist. Sometimes that will happen. Sometimes an unfiled motion or whatever pleading will come my way. Mm-hmm. But I'm pretty careful about not becoming part of a campaign to shape the narrative, especially in service of what's clearly this smear campaign. And so, it's almost bizarre that in this lawsuit where they're getting sued for doing a thing, it certainly appears that they're doing the thing.
Yeah, I think
using
that's
the
right.
lawsuit as a tool.
I think that's exactly right. And let's cut to the punchline, which is that Judge Lyman just denied the motion to compel the records, right? He didn't strike it from the records. He didn't grant sanctions. He just said that the motion to compel is denied, that Blake Lively can then move to dismiss those counts either with or without prejudice based on whether there is agreement or whether there's not. But the fact that she says they're going away means I'm obviously not going to require her to produce those medical records. That's ridiculous. And I think that has implications for the larger discussion we engage in on the show on a daily basis about sanctions in shall we say, other cases? Right, because remember, this is Judge Lyman. He has already sanctioned the crap out of Rudy Giuliani. He has already sanctioned Justin Baldoni's lawyers. He said, I'm going to sanction you again if you abuse this court's docket. And there were no sanctions here, right? He didn't even strike the pleading, right? Like, I think that shows you where that threshold is. It's really high.
Yeah, let me push back on you a little bit, because I understand what you're saying. You're saying, look, we in all of these, like Abrego Garcia and all of the Alien Enemies Act cases, we just talked about the J.G.G. case in the earlier part of the show, judges are really hesitant to impose sanctions, and you're talking about it across the federal judiciary writ large, and I would agree with you, but I don't want to draw a false parallel, because I do think there's something sort of different going on here. In the immigration cases, you're talking about a really serious kind of clash between the judiciary and the Trump administration, and the lower court judges are real sensitive to the fact that the Supreme Court is, shall we say, not real excited about putting, checks and balances on the executive branch right this minute. They were super excited about it last year, but right now, not so much. What I think is going on in this case is that Judge Lyman is really sensitive to the fact that he's kind of in the middle of this media maelstrom, and that if he does anything to sort of sanction Baldoni's lawyers, it's going to become a part of a larger media narrative. I think if he sanctions them, it will be after the trial, that he'll hold it in abeyance, because he's so appreciates what's going on here, right? That he's trying to run a trial, not like combat whatever Justin Baldoni's trying to do on Reddit, and he doesn't want to become a part of the story. And so I think it's qualitatively different from what's going on in the immigration cases.
I think that's a really, really interesting perspective.
And we're back. Okay, let's talk about Mike Lindell, who is being sued by Dr. Eric Coomer, the former director of product strategy and security for Dominion Voting Systems. Lindell spent much of 2021 and the years after defaming the shit out of Coomer by claiming that he was part of a conspiracy to steal the election for Joe Biden. Judge Nina Wang has already declared it defamatory. The things that Lindell said when he platformed and repeated these lies concocted by a conspiracy theorist named Joseph Altman. Altman claimed that in 2020 he was on an Antifa conference call.
Ideologies do not hold conference calls.
I mean, and if they did, it would certainly not be Antifa. But on this Antifa conference call, someone supposedly came on and said, "Hi, I'm Eric, the Dominion guy," and then proceeded to brag about how he was going to rig the election for Joe Biden in 2020. I mean, that's like, there's more believable porn dialogue. It's so ridiculous.
I'm just thinking, where was that guy who could magically rig the election in 2024, man? Like, we could have used him.
Yeah, we probably should have attended more of those Antifa, board meetings. Anyway, Altman says he was on this imaginary conference call before the election, but weirdly, he didn't tell anyone about it until after Biden won. Altman is also a little sketchy about exactly how he knows that Coomer is Eric, the Dominion guy. Coomer's got some weird claims that he found a secret backdoor into Coomer's Facebook account. I'm not usually one to go online and brag that I've hacked into other people's Facebook accounts, because I think that that's sort of a cyber crime, but that is not the subject of this case.
There's so much that is not the subject of this story that we can buy. But bottom line, Eric Coomer says, look, we have subpoenaed this guy Altman to come in and testify during this trial. He is probably not going to show up in defiance of the court order requiring him to be here. But if he does, we think he's going to do this thing that he's done in other trials, which is invoke the reporter's privilege and refuse to answer our questions about how he got on the Antifa call and who provided him access to Dr. Coomer's private Facebook account. And the reason I know that is because the other cases in which Altman has refused to show up are, in some cases, other cases brought by Eric Coomer, where he has sued other Trump allies, goofballs, including Altman himself. And in that case, I guess I shouldn't have to say this, the judge determined that Altman's testimony was, quote, evasive and not credible, and that his story about the supposed Antifa call was, quote, probably false. That judge,
you think?
Yeah, right. That judge ordered Altman to testify about those things, right? Who was the conduit? How did he get access to the Facebook? And Altman refused to do so. The judge sanctioned him in that case. So let's talk about this reporter's privilege, right? Because this is a thing that's very important to you and me, Liz, right? Like as members of the media, right? I certainly would not want a rule that says podcasters or YouTubers don't really count as reporters, right? Like as you pointed out, you and I have sources, right? We keep those sources confidential when they ask us to.
Yeah, and I am sensitive to the kind of suggestion that there is one kind of media, because as you said, there are independent journalists that are doing different work, and there are even independent journalists who are opinion journalists. I mean, I'm an opinion journalist, so this one, I got a flag in this one.
Yeah, I think that's right, but Altman's claims here are really more of a law-shaped object than actual law, right? Like he might be a journalist, but that doesn't make everything he does into journalism any more than, I'm a lawyer. That doesn't make every conversation I have attorney-client privilege. And Altman isn't protecting a secret whistleblower source high in the employ of Antifa LLC, right? He's making up nonsense, which is not what journalists do.
No. So, okay. First, the reporter's privilege is not a constitutional or a federal statutory right. Like journalists have different protections, but those protections are based on state law. Yeah. Here, Colorado law says that no journalist shall be compelled to disclose any news information received, observed, procured, processed, prepared, written, or edited by a news person while acting in the capacity of a news person. Mm-hmm. That's a very highly protective shield law, but it can be rebutted if you get a valid subpoena and you establish by a preponderance of the evidence 3 things that, regarding what the journalist is going to testify about. You have to establish A, that it's relevant to a substantial issue involved in the proceeding, B, that it cannot be obtained by any other reasonable means, and C, that a strong interest of the party seeking the subpoena outweighs the First Amendment interests of the journalist.
And seems pretty likely that Coomer is going to meet that burden, right? Mike Lindell has argued that the things he said about Altman were, quote, substantially true. They put that in their trial memorandum.
Yeah, although I would point out that Mike Lindell's lawyers, when they got in front of the jury, said that they didn't intend to argue that the 2020 election was stolen, that was all just talk. It was just stuff that Mike Lindell said. And how can stuff like words, just stuff that you say, be a tort, man?
Yeah, some kind of tort that rhymes with defamation, right? But okay, so Coomer has to get access to that information, and that has to be weighed against Altman's First Amendment rights. And the problem is that neither Lindell nor Altman have provided any evidence to support any kind of harm to the First Amendment whatsoever, right? They could have introduced sealed or redacted or pseudonymous declarations of Altman's supposed sources, right? And then we'd be having a different fight, right? But they didn't. These guys kept going on frankspeech.tv, whatever, and saying things like this is an actual quote from Altman. They're trying to hone in on the Antifa call. Number one, I have an ace in the deal because at some point I'm going to come forward with that guy. I'm going to. I'm just telling you right now, I'm going to. And it's going to get really bad. It's going to get really bad because at that point, the rest of their argument falls apart. And then all the money they've spent on this lawfare, we get all of our money back. Oh, I'm just telling you.
Is that how it works? You get all your money back?
None of that is how it works.
No. But my favorite part was when Altman said they supposedly sent powder to his house, leading him to fear for his and his family's well-being. But later he had to admit that the package in question was sent by a window company he hired to remodel, and the powder in question was graphite.
We will link to this motion in the show notes, but it's definitely funny, right? Like the 2 pages on why Altman's claim is probably false is great, right? It's things like, hey, if this is a Zoom call you were on, how come you didn't see anyone's face? How come you didn't try and identify the other 19 people you said were on this super secret call? Why did you alter a screenshot that was taken in September before the election to make it look like it was taken after the election? And so on.
Yeah, this trial is such a shit show.
It really
Judge
is.
Wang already had to issue a special instruction before voir dire of all of the things Mike Lindell's lawyers could not ask the jurors. Do not bring them up. Do not hint at them. Do not try me, and so on. And then Mike Lindell, just like on the first day, Judge Wang had a really strong order that said there will be no electronics in the courtroom and there will be no live blogging of this hearing. And you're never going to guess what he did.
The guy with frankspeech.tv?
Yeah. No, amazing. Yes, he was also tweeting from the courthouse. He was texting from the courtroom. He was texting all of these, as we said, the weirdos beat reporters. He was like, I'm texting you. I'm looking at the jurors, and did not impress Judge Wang. He says he's going to do better. He didn't mean to violate your order, Your Honor.
He said, I think I have done a poor job of complying with the court's order. And we do have a word for that. It's called contempt. So we'll see what happens. But at least we get this little bit of delightfulness in the middle of our day.
All right. Well, we're going to be right back and discuss something marginally less delightful. Unless you are a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case you will not be getting ads. Not today, not ever. And we're back. Last week, the Trump administration sued the state of North Carolina and demanded that it purge 200,000 voters from its rolls as retribution for losing a state Supreme Court seat. Well, they didn't put it in those terms, but that's what they meant. And weirdly enough, maybe they're not wrong.
Yeah,
Question mark?
Yeah, this is pretty fascinating. So let's set the legal landscape. And Liz, I have not time traveled back to 13th century Saxony recently, but here I only
Not for lack of trying.
I know. Here I only need to go back as far as 2000 because on election night in 2000, Democratic Vice President Al Gore unquestionably won 267 electoral votes, 3 shy of what he needed for victory. The Republican candidate, George W. Bush, unquestionably won 246 electoral votes, 24 shy of what he needed to win. And left unresolved was the state of Florida with 25 electoral votes, where it just so happened that George W. Bush's brother was the governor. And Republican election officials ordered that state to stop ongoing recounts that were steadily adding Gore votes, and they ordered those stopped when Gore was down by 537 votes across the entire state. Al Gore's legal team went all the way up to the state Supreme Court in Florida, where they won, and they ordered the state of Florida to resume the recount. And then the United States Supreme Court jumped in the very next day with a completely nonsensical, made-up, partisan, unsigned per curiam opinion that ordered the state of Florida, without precedent, to disregard its own election rules and its own state Supreme Court with respect to its own election. That's not something the Supreme Court has done before or since. It froze the results in Florida with Bush up by 537, and you know what happened after that, because the history books do not record a President Gore.
Yeah. In addition to those legal shenanigans, there were lots and lots of practical problems with the election. Palm Beach County in Florida used this butterfly ballot that was virtually impossible to understand and definitely resulted in lots of bubbies and zadies voting for that rabid anti-Semite Pat Buchanan, including my own grandparents, who were pretty chagrined and were pretty sure that they had voted for Pat Buchanan. Anyway, many polling places were not accessible to disabled voters. The recount showed that lots and lots of punch ballots were not being counted. And Democrats in Florida and elsewhere argued that local election workers had turned them away from polls on election day, even though they were eligible and had a right to vote. And after that, Democrats did not storm the Capitol and try to prevent the election from being certified. In fact, they didn't even use any of those irregularities as a basis to try and undermine the electoral result or like throw out legal ballots or whatever. They just pitched that argument to the Supreme Court. And when they lost, Gore conceded.
Yeah, the argument over things like the butterfly ballot was more of a moral one, right? Like our guy should have won. I cannot say this was a good strategy in light of the last 25 years. Yeah, Democrats basically said, look, we didn't riot in the streets after you stole the presidency, so you have to come along with us and at least let us pass some kind of voter reform. And that resulted in the Help America Vote Act, which 2 cheers for it at the time, right? It passed the House 357 to 48, the Senate 92 to 2. It was signed into law by Republican President George W. Bush on October 29th, 2002. That law, pushed by Democrats, was designed to require states to modernize their voting procedures to prevent things like systematic undercounting, not allowing disabled folks to vote, and to establish minimum election standards for administration. And because it was 2002, the implementation of those standards was, by the law, left up to each individual state because laboratories of democracies. But the idea behind the Help America Vote Act, or HAVA, was to address the kinds of issues that you just talked about.
Right. And one good example of that was the provisional ballot. It was created to respond to the complaints of voters being turned away from the polls. And so now, if you show up at a polling place and you're not on the official list of eligible voters, instead of just telling you to go away, the election official has to give you a provisional ballot. So then you sign an affidavit that says you're eligible to vote in that jurisdiction, and they let you vote. And the law, tells each state to find a mechanism to check and see if the person who cast that provisional ballot also voted in another precinct or is, eligible to vote. So if I vote in my actual precinct where I'm registered and then I drive to a different one, they'll give me a provisional ballot and they'll let me vote there. But after the election, the state of Maryland is going to look at those 2 votes and they're going to cancel out the one that was illegally cast.
Right. So the point is that the overall intent of HAVA was to make it easier for people to register and to vote. And one of the provisions of HAVA is 52 U.S.C. Section 21083, and that standardizes the information that a state collects in order to process applications for voter registration. Subsection A5 says that a voter registration application for a federal office, and that's necessary because it's a federal law, quote, may not be accepted or processed by a state unless that application includes either the applicant's driver's license number or the last 4 digits of their social security number. And then there's this catch-all provision that says if a valid voter doesn't have either of those, then the state shall assign the applicant a number, which will then serve to identify the applicant for voter registration purposes. So they make up a unique identifying number in order to help that person vote. Put a pin in that. As it turns out, before 2024, North Carolina used a voter registration application that did not require applicants to provide that information. That form did have fields for the applicant to provide their driver's license number and the last 4, but they were optional, right? Like the application said fields in red text are required, and those were printed in black text. And then the North Carolina Board of Elections posted a video online telling you how to register. And that said, let's look at the voter registration application. The required fields on the application are in red. They are the eligibility requirements: name, date of birth, residential address, mailing address, and your signature.
Right. So in practical terms, that means that in the 2024 election, anyone who registered to vote in North Carolina complied with HAVA, and anyone who filled out the black letter optional fields at any point over the prior 20 years also complied with HAVA. But anyone who didn't do any of those things, who said, oh, I don't have to fill out this thing, I don't have to fill out anything that's but in red, cool, I'm not going to. All of those people did not comply with HAVA.
Right.
And that's a lot of people. So the question is, what should the government do about that? And that finally brings us to this complaint filed by the Justice Department, which we will get to after our last ad break. And we're back. In 2023, sitting state Supreme Court Justice Michael Morgan announced that he was resigning from the court to run for governor as a Democrat, which meant that the Democratic governor, Roy Cooper, was able to name an interim replacement. He picked superstar lawyer Allison Riggs.
Yeah, by the way, Morgan came in second in that primary. He lost to Josh Stein, who is now the governor, giving North Carolina at least 12 years with a Democrat in charge of the state.
Thank you, Mark Robinson. And your browser habits. Okay. Because of this appointment, Riggs had to stand for election to the court on her own in 2024, and she faced off against Republican Judge Jefferson Griffin. That was a high-profile race, even though the North Carolina Supreme Court is 5-2 Republican, or it is even with her on it. Eventually, Riggs won that election, but she won by just 734 votes. Mm-hmm. And after he lost, Griffin brought a ton of legal challenges, claiming voter anomalies and improprieties and demanding that votes be thrown out, although only in blue counties. Mm-hmm. There were no allegations of fraud, but Griffin alleged that 60,000 voters who had been registered without giving their driver's license numbers or the last four of their SSNs should have their votes thrown away. And that argument persuaded the Intermediate Appellate Court in North Carolina, which said that if you were a voter who registered without giving that information, you were never really legally registered to vote. And so your vote should be thrown out unless you cured that defect within 15 days.
And that position was then appealed to the state Supreme Court, which ruled just a month ago in early May that no, they were not going to throw out 60,000 ballots on the basis of HAVA. That court said, okay, fine, maybe the state should have enrolled voters differently, but whatever happened, it's not the voters' fault, right? We're not going to make them cure ballots or do some other thing for just doing what the state told them to do, right? If the state did a wrong thing, we can fix that. By the way, that opinion went up to the North Carolina Supreme Court, and Judge Riggs, of course, recused herself from her own case. But the state Supreme Court did rule in Griffin's favor on a tiny subset of overseas ballots. There were about 5,000 of them. I don't have time to rabbit trail on that. The effect of that would have been to force those 5,000 people to take up to 30 days to cure their ballots, or their votes would be thrown out. And again, 734 vote margin, that seems like it could alter the result. So Judge Riggs went to federal district court and got an injunction against that part of the state Supreme Court's order as well. At which point, Judge Griffin called her up, finally conceded, said, you've been certified, you won, I'm going to drop my legal challenges. Here's the thing. Everything that Judge Griffin complained about was well known long in advance, right? The rules, there's no question, North Carolina should have collected that information, but North Carolina's registration process was known equally to Democrats and Republicans. Griffin and Riggs each could have tried to challenge it before the election, and they didn't. Griffin waited until he lost, and then he ran to court and said, don't certify this election because, you should do these things instead and toss out votes, knowing that any kind of relief would likely change the result. As you pointed out, Liz, those efforts were targeted in overwhelmingly Democratic areas. And that's why the number in the lawsuit was 60,000 non-conforming voters. But the actual number of HAVA registrations is estimated at being closer to 200,000.
Right. I think the difference between that and what we're going to talk about is that he was trying to retrospectively toss out a lot of votes. And that has a really strong echo of the 2020 election challenges, right? I mean, I remember listening to Rudy Giuliani try and persuade a federal judge in Pennsylvania to kind of give the Democratic margin a haircut based on some kind of spurious allegation of fraud. But most of the cases were about invalidating votes, which there's no reason to think that they were, cast in any way fraudulently.
Yeah, that is exactly right. So the question is, okay, we're not going to do this retroactively. What should the state do prospectively to comply with HAVA?
Right. So both the federal court and the North Carolina State Supreme Court left open the question of what states should do going forward to comply with HAVA. And that's what this lawsuit is about. Yeah.
I mean, it seems to me that HAVA did require North Carolina to collect that information before processing voter registration applications. And they didn't do it for 2 decades. And everyone was, fine with it in both parties. But maybe they shouldn't be fine with it. What do you think, Liz?
So I guess what we're saying, we sort of elided over the punchline here, which is that the federal government is now suing and saying, North Carolina, you have to get rid of all of those voters who didn't have this, the social security number or their driver's license number in the registration. And the basis of that is like, perhaps these voters are non-citizens, perhaps they're fraudulent, perhaps they, whatever. But the reality is that Republicans are about purging voter rolls to make it harder for people to vote, right? This isn't about like cleaning the ballots or ensuring election integrity. Like, obviously, this is a vote suppression measure. The problem and the tension for us is that North Carolina kind of violated the law, but there's no reason to believe that any of these voters are, in fact, fraudulent.
Yeah, I think that's right. And I would append one other extreme injustice as a result of this lawsuit, right? Which is, if you remember the pin I laid down, the Trump administration is requesting that the court order the North Carolina Board of Elections to contact everybody in the system who does not have a driver's license number that's included and ask them for their driver's license number and then update those records, presumably kicking off anybody who does not provide that information. And then they turn this section really on its head. They say they want, for registered voters who are contacted who do not report having a driver's license number or the last 4 digits of a social security number, assigning a unique identifier and timely adding that information to the statewide voter registration list, right? And you remember that pin I dropped down, right? That was the provision in the 2002 bipartisan HAVA law that was intended to be inclusive, right? It was intending to say, look, if you're falling through the cracks, you're otherwise eligible to vote, but you don't have a driver's license, and for whatever reason you don't have a social security number, the state will assign you that unique voter ID number. In the age of Trump, you can see why somebody getting a call from the government saying, we're here to help you vote. Oh, tell us you don't have a driver's license and a social security number. Give us your name and we'll give you a special unique number. Like, you can see why somebody might just say, no, just kick me off the voter rolls instead.
Yeah, I agree with you. I understand what you're saying about people being leery of giving information to the government. But I think you don't even have to kind of play it out in that way. Like, people got shit to do. We're all super, super busy and paying the rent, paying the mortgage, paying your taxes, paying all of your bills. That takes up a lot of people's bandwidth for admin stuff, right? Who among us hasn't gotten 16 emails from Google being like, we're going to delete all your, photos or all of your documents if you don't upgrade, or you know what I'm saying? We're all just trying to live. And if you get an email or a call from, the state that's like, come and tell us your driver's license number or your social security number, you don't have to imagine people being afraid. You just have to remember that people are busy living, right? And the people who are busiest living are going to be the younger people who skew more Democratic and who aren't going to pick up the damn phone, obviously. I don't pick up the phone for people I don't know. So I think I would agree with you that this is suppressive of the vote. And I blame the feds. I blame the Justice Department. Obviously, this is about vote suppression, but also, Jesus, North Carolina, you set this situation up.
I mean, in fairness, they did fix it in 2024. The question is, how do you fix the records?
Okay, but after 20 years, if you fix it after 20 years, you planted this landmine under your own constituents. Yeah,
well, we will see what happens, how the court fashions relief, but I think that accurately summarizes it, right? North Carolina did not comply with the law, and the question is, how does a court, unwind the sausage at this point? I think I screwed up that analogy, but we're going to let it stand.
All right. Well, have a lovely weekend unwinding the sausage or whatever normal stuff that you guys are going to do. Thanks for hanging out with us. If you can support the show, we'd appreciate you becoming a subscriber at patreon.com/lawandchaospod or lawandchaospod.com. And if you would be so kind as to leave us a lovely 5-star review on your platform of choice when you're taking a break from unwinding the sausage. We'll be back on Monday with written content and on Tuesday with another show. See you guys.
Law and Chaos Podcast is a production of Ray Zipson Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Ray Zipson Media, LLC, all rights reserved.